Okay, so good day everyone. So for today, we're going to discuss about the research implementation and dissemination in copyright and patent. No, so research implementation is the process of translating research findings into practical applications that benefit society. So it involves the integration of knowledge gained from scientific investigation into real-world scenarios. So this steps is crucial in maximizing the impact of research by turning theoretical insights into tangible solutions. Dissemination in the widespread distribution of research findings to different audiences, including the scientific community, policymaker, and the general public. Effective dissemination ensures that the knowledge generated is accessible and it can be utilized by various stakeholders. Utilization refers to the applications of research outcomes in practical settings, and this involves incorporating research findings into policies, practices, or products to address specific challenges or improve existing processes. The successful utilization is a key indicator of the practical relevance and impact of the research study. Copyright safeguards the intellectual property rights of researchers by providing a legal protection for original works. In this context of research, this includes written publication, software code, and other creative outputs. So researchers can control how their work is used, reproduced, or distributed, ensuring proper attribution and recognition. Patent play a vital role in protecting novel intervention resulting from research. Unlike copyright, which protects expression of ideas, patents safeguard new and useful invention. Researchers can apply for patents to secure exclusive rights to their innovation, encouraging investment in further development and commercialization. And to give us more details about topic, let us all welcome our presenter.
Good day, everyone. I'm Aaron Irel Pituason. I'll be discussing the research implementation, copyright, and patent. What is copyright? Copyright is a legal means of protecting an author's work. It is a type of intellectual property that provides exclusive publication, distribution, and usage rights for the author. This means whatever content the author created cannot be used or published by anyone else without the consent of the author. Different types of content can be protected by copyright. This includes books, poems, songs, films, and artwork. In modern times, copyright protection has been extended to websites and other online content. This means that any original content published on the web is protected by copyright law. This is necessary as a lot of people copy and paste other people's work in this digital age. A copyright usually consists of the following four components. First is copyright symbol or the word copyright. Second, year the material was published. Third, name of the copyright owner. And lastly is what rights are retained by the copyright. This is an example screenshot labels all four copyright components. There are technically two types of copyright examples. One allows you to reuse copyrighted materials in specific ways for fair use purposes without the owner's permission, and the other protects your content from reuse or reproduction as the owner of the work. Fair use is a legal doctrine that allows the limited use of copyrighted material without the need for permission or payment to the copyright owner. It is based on the principle that certain uses of copyrighted material are considered acceptable for purposes such as criticism, commentary, news reporting, teaching, scholarship, and research. Fair use is context specific, and courts consider factors such as the purpose of use, the nature of the copyrighted work, the amount used, and the effect on the market value of the original work. For owner-exclusive rights, when you create original content, you automatically become the owner of the copyright for that work. Copyright provides the owner with exclusive rights, including the right to reproduce, distribute, display, and perform the work. Other generally need permission from the copyright owner to use, reproduce, or distribute the copyrighted material. Understanding these aspects is crucial for both content creators and users to navigate the legal use of copyrighted materials while respecting the right of creators. Fair use provides some flexibility for certain use cases, but is essential to be aware of its limitations and the specific circumstances in which it applies. What is patent? A patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. The World Intellectual Property Organization states that the law of patents is a legal framework that establishes a patent system which supports and encourages technological innovation and promotes economic development. The duration of a patent is a period of 20 years counting from the date of filing of the patent application except where the patent lapses, is surrendered, or is declared a nullity by a court of competent jurisdiction. Applications for a patent must be made to the Registrar of Patents and Copyrights. A search must first be carried out to ensure that the product has not already been patented. After the search has been completed, then the inventor is free to go ahead and proceed with the registration. Types of patents. There are three types of patents available: utility patents, design patents, and plant patents. Each has its own specifications and durations. Utility patents, or patents for invention, issue legal protection to people who invent a new and useful process, an article of manufacture, a machine, or a composition of matter. Design patents are patents issued for original, new, and ornamental designs for manufactured products. Design patents protect the design or look of something. They require the invention to which the design belongs to be original and useful. Plant patents go to anyone who produces, discovers, and invents a new kind of plant capable of reproduction. Patents provides an incentive for companies or individuals to continue developing innovative products or services without the fear of infringement. In other words, patents protect the intellectual property of companies to help their profitability. However, patents also serve as bragging rights for companies demonstrating their innovativeness. Copyright and patent in research implementation. Applying copyright and patent protection to research implementation involves different processes and considerations. It's important to note that copyright and patent protection serve different purposes and cover different aspects of intellectual property. Here's a brief overview of how to apply copyright and patent to a research implementation. First is understand copyright. Copyright protects original works of authorship fixed in a tangible medium such as text, software, and other creative works. Copyright protection is automatic upon creation, and registration is not required. However, registration can provide additional benefits. Second is documentation. Keep through documentation of your research implementation, including code, documentation, and any other creative aspects. Third is include copyright notice. Add a copyright notice to your work indicating that it is protected by copyright. For example, copyright year and your name or organization. Fourth is consider open source licensing. Decide whether you want to make your work open source. If so, choose an appropriate open source license and include it with your project. Last is register copyright. While registration is not required, registering your copyright with the relevant copyright office can provide additional legal benefits in case of infringement. Patent. First is understand patent protection. Patent protects inventions including processes, machines, and compositions of matter. They must be novel, non-obvious, and useful. Second is determine patentability. Assess whether your research implementation is eligible for patent protection. Some software-related inventions may be patentable. Third is document your invention. Keep detailed record of your invention, including the problem it solves, how it works, and any variations. Fourth is file a patent application. Consult with a patent attorney to prepare and file a patent application. This is a complex process and typically involves a detailed description of the invention and claims defining the scope of protection. Fifth is public disclosure considerations. Be cautious about public disclosure before filing a patent application, as some jurisdictions have a first-to-file system. Public disclosure may limit your ability to obtain a patent. 6. International considerations. If seeking international protection, explore the process for filing patents in other countries through national or international patent offices. And last is enforce your patent. If granted, a patent gives you the right to exclude others from making, using, selling, or importing the patented invention. You may need to enforce your patent rights if infringement occurs. Remember that intellectual property laws can be complex and may vary by jurisdiction, so it's crucial to consult with legal professionals for personalized guidance based on your specific situation. That's all. Thank you.
Okay, so the intellectual property right, no, for IT-based technologies, no, the information technology covers set of hardware, no, software, and associated services, no, which attract intellectual property rights in a general sense, subject to novelty, non-obviousness, and utility aspect. And some common IT products and services that are protected for IP are hardware, software, databases, internet, electronic publishing, web processes like e-commerce, domain names, trademarks, and cyber contracts or contracts. No? Application of intellectual property in each of these with special reference, of course, to our country and its cyber law, of course. So practical application of computer-related innovation is patentable. Through softwares, no, per se, are not patentable. Specific software products that have a useful practical applications are patentable, like software used in devices like pacemakers. No, utilities of invention must be within the technological arts. Now, a computer program is eligible for patenting if it makes technical contribution to the known art. No? If a program can make a system work more fast and or efficiently, then it is eligible for patenting. No? Only a claim having a practical applications in the technological arts is statutory and hence patentable. And some typical software patents are ideas, systems, methods, algorithms, and functions in software products. No? Editing functions, user interface features, compiling techniques, no? Operating system functions, no? Program algorithms, menu arrangement, display presentation arrangement, and program language translation. In the United States, no recognized methods of doing business patentable now, and this brought a range of process like e-commerce, no, e-gambling, and online stock trading as patentable. For the non-patentable, no, softwares per se are intangibles and not protected by patents, but are protected by copyrights as applicable to literary and aesthetic works. A computer program is therefore dealt with a literary work, and the law and practice in relation to literary works will apply to computer programs. The software includes musical and artistic works, studio and video recordings, database and preparation material, associated documents like manuals. No? Programming languages such as Fortran, BASIC, COBOL, C, Java are treated as languages like English and are not protection than the patent law allows. No? Mathematical algorithm or computer programs are not held as invention because they merely describe as an abstract idea. They merely solve a mathematical problem and not a practical uh, solutions, no, for that problem. So there are significant difference in protection by patent and copyright acts. No, patent protection is much stronger, whereas copyright protection is longer. Some major contrasting features of these two forms of protection are: patent law protects the technical idea underlying the invention, the functional elements. No, copyright protects the form in which the idea is expressed. No, originality, the expression. Copyrights become effective the moment they are published or made known, whereas patent needs to be filed. No, copyrights last for authors life plus 60 years, where patents are granted for a period of 14 years. No, patent provide much stronger protection to software. Development of software using known algorithm or logic, but using different language or coding, is not copyright violation, whereas it is a patent violation in terms of violating a protected concept of software. Presentation of known information is not innovation, but the form of presentation can be protected by copyright. No? So patents and trademarks are statutory and hence protected by respective governments with their jurisdiction. Common law right is, in a universal perspective, protects copyright as most countries are signatories. No, both revised in 1971. In other government agency, now has been an active participant in protecting the rights of copyright holder. Both Department of Electronics and other human resource development have actively helped in bringing amendments to the Copyright Act. No, the Copyright Act is amended to extend its coverage to computer software also. No, computer was one of the first countries in the world to provide statutory protection to computer software, and it is one toughest in the world. No, major changes to copyright law introduced in 1994. So it covered the definition of computer program, explained the rights of copyright holder, position on rentals of software, the rights of the user to make backup copies, and punishment in fines of the infringement. Database is a collection of data or works arranged in a systematic and methodical way and capable of being accessed. Like softwares, database are copy protected. However, no protection is available if the data is mere compilation or result of labor only. If database is adoption of prior work, like dictionaries, then it is protected under copyright. If database has no such prior and selection existing as a software literary work, such as survey data, law is not clear in such people-generated data using computers. No, there has to be originality in design, structure, and selection of elements for a database to be protected. It can be protected for individuality, no, data sets, and also for the compilation. In other words, protection is given to database requiring skill or judgment. So to protect investment in database which fail to satisfy copyright law, a sui generis right is available. This need proof of investment, time and resource in making it, and so on. A licensed database can be used as long as its use does not prejudice interest of original developers. Data can also be protected under the trade secret laws, no, through contract laws or agreements enforcing employees to sign privacy conditions. As many organizations keep valuable data, it is common practice to protect the data under the contract laws with increasing electronic transaction both in public and private. No, various countries are providing consumer privacy under cyber law. Internet or cyberspace. No, any information placed on internet is considered as a public domain knowledge. This gives right to others to use it, but does not give rights for commercial purposes. So one has to be careful in using the information available on net for commercial purposes. The origin of broadcast in actual use can be different in different geographic location and jurisdiction. Normally, any misuse is treated as offense at place where offense took place. So, for placing information on net, one has to be careful about laws of all jurisdictions where the site can be accessed through the internet. Unlike newspaper, internet cannot have control on distribution even if intended. Cyberspace is theoretically subjected to jurisdiction of all the world legal system. By its nature, internet makes territorial application of national laws obsolete. There are moves to develop a separate law for cyberspace, which will become applicable anywhere with certain flexibility in terms of limits while making territorial laws. No? In other countries, it is one of the first few countries to law most IP items can be used peerlessly for academic and research purposes without any commercial intent. Electronic publishing or electronic journals are a good example of electronic publishing. No? In such item licensing agreements are very important as any use beyond the scope of license will be a copyright violation. Facilitators need to be careful on who are accessing the type of use. So the facilitators are vulnerable if they are not careful on agreements while subscription are made. One way to minimize the risk is to post warning notices and educate the users about copyright law. Nevertheless, one should carefully check the indemnity clauses of contract. What are the challenges in copyright and patenting? While copyright and patents offer protection, challenges arise. Balancing the need of protection with the principle of open access can be complex. Additionally, navigating the legal intricacies of patenting, such as demonstrating novelty and non-obviousness, possess challenges for researchers seeking exclusive rights. Ethical consideration are paramount throughout the research life cycle, including implementation. Researchers must ensure that the dissemination and utilization of their work align with ethical standards, considering factors such as potential harm, fairness, and responsible application of knowledge. Collaboration is often key to successful research implementation. Working with the stakeholders from diverse backgrounds enhances the practical applicability of research outcomes. Collaborative efforts foster a more comprehensive understanding of problems and increase the likelihood of successful utilization. Research implementation often extends beyond national borders. International collaboration is essential for addressing global challenges and sharing knowledge. No? Researchers must navigate varying legal frameworks related to copyright and patenting, requiring a nuanced approach to ensure global research accessibility. The future of research implementation is influenced by technological advancement, changing societal needs, and evolving ethical consideration. A new field emerged such as synthetic biology and advanced artificial intelligence. And as a researchers must adapt copyright and patenting strategies to facilitate responsible and innovative implementation in an ever-changing landscape. So I think that's it.